perpetuating Waqf in India is what broadly I'm going to argue in the method section of this paper. In the theory section of this paper, I invoke the thesis of H.L.A. Hart, who in his famous book, The Concept of Law, talked about the vital aspect of rules, where he went on to criticize legislations as a soft positivist, saying that legislations do not work largely because of three main features that legislations inbuilt. Going on to discuss what comes from the Waqf, which largely means to halt or to detain or stop or restrain, which is also the integral part or an essential to Waqf, which is inalienability about it. So once a Waqf is declared as a Waqf, it becomes inalienable. It cannot be taken away. Once and for all, it is set. Now, if you look at the name of this act itself, it said Mussalman Waqf Validating Act. The purpose of this act was merely to validate a concept which was already existent in Indian law. What I want you to understand here is that judiciary had already created and given a substance to this concept, which was a substantive concept in law, recognized through the Islamic practice called the Waqf law, Shariah being followed, and the legislation did not create it but merely validated this act. This for the first time came in the 1995 Act, and they qualified that Waqf by user would be recognized, but such work shall not cease to be a Waqf by reason only of the user having ceased, irrespective of the period of substitution. What it largely meant was, even if there is no document that recognizes a Waqf by user, the mere usage of the property for religious, pious or charitable purposes gives the power to the judiciary to recognize it as a Waqf. It gives the power to the board as well. 2013, in the case of Court of Wards of Property of Makhdoom Hassan Baksh versus Ilani Baksh, the Supreme Court said that the Waqf by user is based on consistent evidence of usage of place and is a rule of necessity. And I quote what the court said. This is the Privy Council, which was the highest court of the land those days. In the case of an old Waqf, it is not possible to secure direct evidence of dedication, and also it has been ruled that even in absence of such direct evidence, a court can hold a Waqf to be established on evidence of long use. I'm Saifuddin Patel, assistant professor of law at H.L.A. School, Mumbai, which is under the aegis of Privy. I take courses on, my domain area is largely legal theory. I am not by any stretch of imagination a religious scholar as most of you in the room are. But I've tried to create an argument from theoretical lens to understand and largely to question the recent Waqf amendment that is passed by the government. So the title of my paper today, which is Waqf by User, Clearing Complications to Theory and Method. The title itself has two broader domains. One is theory and one is method. So what is it that I'm talking about here? The method is the common law method of adjudication, which has been followed in UK since the last 700 years, and in India since at least last 150 years, and it is a proven method of interpretation in the Commonwealth nations and largely in UK and India. India has though deviated from the English common law understanding to something very different, which I have argued in my PhD thesis. But what I take here, and I'll come to it, is a method of common law which I think has helped us to arrive at the concept of Waqf itself, which I believe is not a legislative concept but a concept of procedure which is developed after a number of cases were decided on the point of law, and how this method has far more potency in understanding and perpetuating Waqf in India is what broadly I'm going to argue in the method section of this paper. In the theory section of this paper, I invoke the thesis of H.L.A. Hart, who in his famous book, The Concept of Law, talked about the vital aspect of rules, where he went on to criticize legislations as a soft positivist, saying that legislations do not work largely because of three main features that legislations inbuiltly have. One is the indeterminacy of aim, the other is open texture of language, and there is the third one, which is ignorance of fact. So these three, because they are inbred into the legislation itself, legislations largely do not work in a common law conceptual setting. So I'll first set the scene of how Waqf can be looked at from the common law method of understanding it, and it is not a legislative construct but only recognized by the legislature or validated as the law speaks about it, and then go on to explain that how this point is also illuminated by theory of H.L.A. So that's the larger paper that I'm going to talk about. And I think there'll be some questions and some grappling, because even I'm trying to understand this idea of whether it fits the argument of Waqf itself. My paper starts with this quote which I read in St. Augustine's book, which I think is very apt to the discussion on Waqf law, is justice being taken away, then what past kingdoms great robberies. What this illuminates me to is the two extremes within which the philosophical debate has fluctuated. Which is one is morality and the other is law, where there has been the famous Hart debate, which I invoke as well. And the first extreme of morality is the often quoted term in moral law that an unjust law is no law at all. So are we looking at the Waqf law as an unjust law itself, or we are on the second end of the spectrum, which is the existence of law is one thing and merit or demerit of it is another, which is famously spoken by John Austin in his book, The Province of Jurisprudence Determined. So are we looking at the demerits that the government is trying to portray in the Waqf legislations, which in a way takes the merits that it has, that everyone has spoken about in this conference, away and kind of makes it a demeritorious legislation to have for India, which Senior Advocate Shamshad has already spoken about, that it is not existent in other religious endowments, but the government is trying to regulate only the Muslim endowments. So I argue that the Waqf law struggles on both these grounds. It struggles on the moral aspect as well as the legal aspect of the law. Going on to discuss Waqf, what comes from the term waqafa, which largely means to halt or to detain or stop or restrain, which is also the integral part or an essential to Waqf, which is inalienability about it. So once a Waqf is declared as a Waqf, it becomes inalienable. It cannot be taken away. Once and for all, it is set. Which is also in certain parts of Africa called as hubs, which means confinement of a property. That means it becomes perpetual then and thence. So the concept of charity in Islamic law, which is one of the 5 main pillars of Islam, is done in largely 3 ways. One is the individual giving of alms, which we call sadaqah in Islamic law. The second is the obligatory charitable contribution, which is zakat, which we give throughout our incomes every year. And the third one is a more institutional endowment, which is considered as Waqf in India. Quoting a famous philosopher and a Muslim scholar, efface, on this, he says that Waqf is largely an institutional form of charity for the betterment of cultural and life of others. So, and hence also this topic becomes important to us. What I want to illuminate in the second section of my paper is that the first act, obviously there were Religious Endowments Act, which also Senior Advocate has spoken about earlier in his discussion, and I cannot do it as well as he has done it in the morning. But the debate actually in India through a central legislation started in 1930 when the Muslim Waqf Validating Act came onto the scene. Now, if you look at the name of this act itself, it said Mussalman Waqf Validating Act. The purpose of this act was merely to validate a concept which was already existent in Indian law. What I want you to understand here is that judiciary had already created and given a substance to this concept, which was a substantive concept in law, recognized through the Islamic practice called the Waqf law, Shariah being followed. And the legislation did not create it, but merely validated this act of Waqf being granted. Okay, so this happened in 1930. The Supreme Court of India has kind of looked beyond this in their recent judgment in the Waqf Amendment 2015 order, where they said that for the first time the Waqf enactment was only the Muslim Waqf Act of 1923, not 1913. Now the Muslim Waqf Act 1923 does not use the word validating, but the 1913 Act did, and also the 1930, which was an extension that retrospective effect will not apply to 1913 Act, also used the word validating, but 1923 Act did not. And Supreme Court, it's my humble submission that conveniently chose this Act to say that this was one of the first legislations of Waqf in a central setting in India. which is largely on historical grounds as well as factual grounds incorrect, and I think they look beyond it, where they should have recognized that this is only a validating provision and not a creation of the legislation. The Solicitor General of India argued in the Supreme Court, if I'm not wrong, that it is a legislation. It is the Waqf was created by a legislation and hence can be taken away through a legislation, which is largely factually incorrect. Post-independence, India drafted the Muslim Waqf Acts 1954, which for the first time laid down a comprehensive definition of Waqf, and this is also where my paper is taken from. And I quote section 3.1 of this act saying that Waqf means the permanent dedication by a person professing Islam of any movable or immovable property for any purpose recognized by Muslim law as pious, religious or charitable, and includes, and they list down three things. First is a Waqf by user, specifically the domain in which my paper is written. The second is Mashrutul Khidmat, and the third one, which has also been spoken about in this conference, is the Waqf al-Allah. Okay, but there was no qualifiers attached to this Waqf by user concept, which I'm going to talk about here, which for the first time came in the 1995 Act, and they qualified that Waqf by user would be recognized, but such work shall not cease to be a Waqf by reason only of the user having ceased, irrespective of the period of subseizure. What it largely meant was, even if there is no document that recognizes a Waqf by user, the mere usage of the property for religious, pious or charitable purposes gives the power to the judiciary to recognize it as a Waqf. It gives the power to the board as well, but if the board is not able to recognize it, the tribunal or the court has the power, as the law says, to recognize the property as Waqf. This also came out in the famous treatise of Mullah, which has been quoted by the Supreme Court in one of its constitutional bench judgments, which I'll come to. And it says that if the land has been used for time immemorial for religious purpose, example for a mosque or a burial ground or for maintenance of a mosque, then the land is by user Waqf, although there is no evidence of an express dedication. That means no documentation is required for this type of Waqf to be recognized. The government is claiming that there should be compulsorily a registration of this Waqf. This Waqf by user category was created in Islamic law so that through perpetual immemorial use of a land for religious, pious or charitable purposes, it can be recognized as Waqf. There is no need of a declaration. And I will come to why declaration is also important, but there is also an empirical data which would support my claim here, is that there are 8.72 lakh Waqf properties according to the Waqf asset management systems in India, out of which almost 46%, which is 4.02 lakh properties, are classified as Waqf by users. That means it's a broad and a big category in India where it's recognized. So the argument of mismanagement of Waqf board, though it stands, there's on record that almost 46% of such properties has been recognized by the board. APCC has raised further claims about it, but that's not integrally important to the argument that I'm making. The next argument I go to is judicial interpretation of Waqf by user by the judiciary. Now, if you remember in the first part, I made an argument that it was not a creation of the legislature. This means that there should be some evidence for its recognition in the courts itself before 1930. Yes, there was certain Endowments Act and the Bengal Endowment Act or even the Charitable Endowments Act in India in 1890. However, the argument is that 2013, in the case of Court of Wards of Property of Makhdoom Hassan Baksh versus Ilani Baksh, the Supreme Court said that the Waqf by user is based on consistent evidence of usage of place and is a rule of necessity. And I quote what the court said. This is the Privy Council, which was the highest court of the land those days. In the case of an old Waqf, it is not possible to secure direct evidence of dedication, and also it has been ruled that even in absence of such direct evidence, a court can hold a Waqf to be established on evidence of long usership. Okay, so the court already had recognized this concept, and the legislation merely validated this concept. The broader theoretical argument I'm trying to make here is that, which was also spoken about by Dr. Nizamuddin earlier in the conference, which is that the cases lead to the rules don't lead to the cases. It is an inductive method of reasoning which is being followed when multiple number of cases are decided on a point of law and a general principle emerges. The general principle that emerged out of the court's practice or process here was the Waqf by user concept in India. However, what what the argument in the Supreme Court was that this is a general principle created by the legislation, and hence through this deductive logic, we have a broader first principle of work by user, and the Supreme Court or the other courts should adjudicate only based on this written law. However, the creation of this law was through an inductive logic, and this concept exists independent of the legislature being there. This is what I go on to argue in my, and I cite a plethora of cases which I think the paucity of time does not allow me to go into. However, what I want to stress is on 3 cases Supreme Court of India. 2 of them are constitutional bench judgments which have recognized the concept of Waqf independent of a legislation. The first one is Fakir Muhammad Shah versus Qazi Fasiuddin Ansari. The second one is Sayyid Muhammad Salih Labai versus Muhammad Hanifa. And the third one is the recently passed one and a quite famous one is M. Sadiq versus Suresh Das, which is also the Babri Masjid of the Ram Janmabhoomi judgment. I want to quote a paragraph from this judgment if time allows. Our jurisprudence recognizes the principle of work by user even absent an express deed of dedication or declaration. Now please pay close attention to the next sentence that I'm going to read. Whether or not properties are Waqf property by long use is a matter of evidence. Okay? This is where the common law understanding of logic comes to be. Now, when I move to the fourth part of my paper, I come to the common law theory and the common law method which I am talking about. Now, scholars have argued that common law is best understood as a process rather than a body of rules. It is the casuistic method of deciding cases which is followed here. Now, what is this casuistic method? Going from one case to another without a rational blueprint for the case. Okay, so here the rational blueprint does not matter a lot. There is no abstract universal first principle that matter. It is the context and the evidence in every case that leads you to a decision. And obviously analogical reasoning will follow. Okay, so common law principle or common law method works on the principle of crossing the bridge when we come to it. Not deciding that this is what we need to do in the first place, but letting the cases take their own turns. As Lagrange famously argued, in common law, legal knowledge emerges from facts rather than from rules. This is why I argue that inductive logic was working far better in India rather than deductive logic. In short, what I'm arguing is the positivistic rules follow the cases and not the other way around. Okay, so once the cases are decided on a number of areas, the rules should emerge from the cases and not the other way around. I have ample evidence of this which I have quoted. Let's look at the 1913 Act of how it came into being. Muhammad Yusuf Khan Bahadur went on to state in a private paper that it was seldom that we come across a decision on a disputed question of moral law where there is consistency in the decision making of the court. In one of the cases, Rosemary Dool Chaudhary versus Abdul Fattah Muhammad, the judges were from Tottenham and Trevelyan, which is a part of the UK. They were sitting on the Calcutta High Court at that point, and the judgment was also appealed to the Supreme Court of India, where it kind of went beyond the Waqf Validation Act of 2013. And when a judgment was adversely given, there was an amendment made to these statutes of 1913 in 1923 and 1930, which actually followed the cases. So the common law method that I'm arguing is also in historical evidences based in law. So when the courts were making any mistake or courts were rightly expounding a proposition of law, the parallel amendment into the statute was carried out. What I'm arguing here is that the common law changes only when problem arises in the application and not in the administration. The problem with the Waqf Act, what the government is trying to claim, is with the administrative aspects of the law, which in my humble opinion is not a ground for the complete eradication of the concept of Waqf by user. If there are certain administrative problems in the law that can be figured out and that can be molded only through streamlining administrative processes rather than eradicating the concept from the law itself, which in my opinion does not obtain. Mere allegation of misappropriation or misadministration of the Waqf board should not lead to a complete eradication of the concept of the Waqf law itself. And if you look at the anecdotal data that the lawyers in the Supreme Court have given, they say that in the state of Andhra Pradesh, there is certain mismanagement by the Waqf Act. However, if you look at the state of Andhra Pradesh versus the state Andhra Pradesh Waqf Board, it is merely decided on a common law concept that the evidence was not found, and hence we will not allow Waqf by user. So even if the law doesn't exist, this is the way the courts are going to decide the cases. Even if you look at the Ram Janmabhoomi case, which gave a recognition stamp to the Waqf by user, they also said that the disputed site is not Waqf by user because there is no evidence of it. So if the law is being decided based on evidence, creating this rationalist blueprint in a hardcore positivistic law that we're going to eradicate the concept, in my opinion, does not obtain, which is also what H.L.A. Hart is talking about in the three concepts that I told you, the concept of law. This is his theory of vital aspect of rules, and I'm going to list down the three and state the three problems, which will be largely the end of the paper. The first one is about the ignorance of fact. Now there can be multiple fact that comes in that the judiciary needs to take care of, which should be decided on a common law method. Now supposedly, if this amendment is given a heads up by the Supreme Court of India and it allows this amendment to go through constitutional checks, what will happen is that there will be confusion whether you do not believe in a Waqf by user being recognized or being eradicated by a legislature, or do you follow the old concept that it is already embedded in Islamic law and theological practice of Islam? So does the court follow, in this gap, what does the court do? Does it go back to the religious practices of Islam and say that Waqf is recognized as a concept independent of the legislation, or they say that no, it has now been removed by the legislation and hence we are not empowered to pass any such order? In this case, the Supreme Court can also use its power to do complete justice under 142 and give a ruling that would be considered as unpredictable, so to speak. The second is the second concept that Hart talks about is about the indeterminacy of aim. Now, the aim of the legislature here seems to be that there's a misapplication by the Waqf boards, and hence it needs to be eradicated. However, historical evidence shows that in Dargah Khwaja Sahib Act of 1955, which is the Ajmer Dargah's Act, there were certain inconsistencies in the operation of the board there itself, and there were certain amendments made in 1964 which made more accountable administration, and they created specialized tribunals with stricter evidentiary rules. This could have been done in the Waqf Act, but the government has kind of played a blind eye to it, and the argument is that the last resort is always not the best resort. So the aim of the legislature here seems to be a little dubious, to speak the least. The third is the open texture of language. Now, any legislature would be drafted, it will be open and amenable to interpretations by the courts, and this would go antithesis to the common law method of deciding. The larger question is that is legislation even a tool to rectify the mischief that the parliament is trying to handle here? The mischief being the misapplication or the problems in the working of the Waqf board. Is legislation a good enough tool to kind of eradicate these practices? And the last question that remains in my paper is that whether a parliament can eradicate a customary practice through a legislation when it was not created through a legislation but created only through a common law method of inductive reasoning. I think I require more delving into it too, so that it appears to be a complete paper, but that's my presentation. I'm open to suggestions and open to questions.